The smart and meticulous final address of the Labour Party is here, and it's quite a long read. Let's start with the response to the election. Labour Party said in their final address that after conducting data analysis for the 18,088 polling unit blood results on the IREV, that they represent 2.5,065,269 accredited voters. Probing further in these polling units, 9,165,191 voters collected their PVCs in these polling units. So the number of accredited voters is higher than the margin between Tinubu and Peter Obi. While it's acceptable that all the accredited voters in the more than 18,000 polling units that their results are blurred didn't vote for one candidate, but without determining their numbers, it renders the announced results invalid. Mind you, these are not the only votes unaccounted for by INEC. According to the data analysis by Labour Party's witness, which was unchallenged by the respondents, 39,546 polling units are inaccessible on the IREV. And in these polling units, a total number of 23,119,298 registered voters collected their PVCs, and 5,532,553 voters were accredited on election day to vote in these polling units. So when you add this figure to the other 2.5 million, the unaccounted votes are more than 8 million votes, which is too high when you look at the margin between Tinubu and Peter Obi based on the INEC allocated figures. So what the LP legal team are trying to say here is that there was massive suppression of votes by INEC, and they shouldn't have called the election without accounting for all the votes, especially when the unaccounted votes are higher than the margin between candidates. Recently, INEC had to declare some governorship elections inconclusive because unresolved and unaccounted votes were higher than the margin of lead. Why didn't they do that during the presidential election? And INEC, hoping that there's insufficient evidence to prove this, having not provided the hard copies that represent the blurred and inaccessible results, the Labour Party is asking the question, if their witness claimed that they collated the results with hard copies and the blurred copies didn't affect the outcome, why didn't they tender the hard copies in court to prove it? If the hard copies are truly in their possession, also, why didn't they certify the hard copies and deliver them to the Labour Party? Instead, they certified blurred IREV copies that are unreadable. Some are not even results, but images from other things. So in the absence of hard copies from INEC, Labour Party are telling the court to invoke presumption of Section 167 subsection D of the Evidence Act in their favor. They also cited a Supreme Court judgment between Danladi and Dangiri 2015, where the Supreme Court held that if an admitted document is incomplete, the party to be damnified is the one who ought to have produced the proper or correct and complete document, if he failed to produce the said document in its correct form. So based on this, they are asking the court to refer to the 18,088 blurred copies as the results for the election. They also said that the alleged technological glitch on the day of election isn't a valid justification for the outright violation of the Electoral Act, INEC regulation and guidelines, and the manual for election officials. Like you already know, we've covered these extensively. All these laws make the upload of forms EC8As to IREV mandatory from the polling units immediately after vote counting. INEC in their final address claimed that the Federal High Court, while delivering judgment on the case between them and the Labour Party, held that they can conduct election and do collation anyhow they wish. This judgment, the Labour Party legal team said, is inferior to that of the Supreme Court on Oyetola versus INEC. Also, INEC in their final address argued that their guidelines and regulations are not binding, that they are ordinary documents. Let's see how the Labour Party countered. They quoted a judicial precedent by the Supreme Court, Faleke versus INEC. In that judgment, Honorable Justice Ogunbiyi said, the Manual for Election Official 2015, which makes a substantial part of the one INEC is using now, the 2023 version, he said that they are not mere instructions or directions, rather they are subsidiary legislations which have the force of law. They have their origin from the Constitution and the Electoral Act. This is true. That's why you see citations of the Electoral Act in the manual. Let's see what the INEC guideline says in paragraph 2. Election transmission and upload of election results and publish into the INEC result viewing portal. One of the problems noticed in the electoral process is the irregularities that take place between the polling units after the announcement of results and the point of result collation. Sometimes results are hijacked, exchanged, or even destroyed at the polling unit or on the way to the collation centers. It becomes necessary to apply technology to transmit the data from the polling unit such that the results are collated up to the point of result declaration. The real-time publishing of polling unit level results on IREV portal and transmission of results using the BIVAS demonstrates INEC's commitment to transparency in results management. This commitment is backed by sections 42 subsection 2, 60 subsection 1, 2, and 5, 64 subsection 4A and 4B, and 64 subsection 5 of the Electoral Act 2022, which confers INEC with the power to transmit election results electronically. The system minimizes human errors and delays in results collation and improves the accuracy, transparency, and credibility of the results collation process. So how can INEC overlook all these and say that uploading of results is not mandatory and that the non-upload didn't affect the results? The Labour Party legal team cited Section 60 of the Electoral Act 2022. This section not only makes it mandatory to upload results, it also provides punishment for presiding officers who fail to follow the law. They can be imprisoned or fined if they are convicted. Also, Labour Party said that according to their cybersecurity expert witness that INEC did not properly test their IT infrastructure deployed for the conduct of the election. The expert found many vulnerabilities and INEC failed to comply with the standard and guidelines for government websites. And since this evidence was not countered, none of the respondents tendered any other test report to the contrary. Labour Party are asking the court to invoke presumption based on Section 167 subsection D of the Evidence Act. And going by all these evidence submitted by the petitioners that they have established the non-compliance by INEC, and non-compliance was not only substantial but grievously affected the outcome of the presidential election. They also highlighted the data analysis by the mathematician that proves that Labour Party won Rivers and Benue states. The results he computed were gotten from Forms EC8As uploaded on IREV and the certified true copies of Forms EC8As given to Labour Party by INEC. So going by this unchallenged report alone, Labour Party will add 2 states to the number of states they won, while the APC will lose 2 states. Based on all these, Labour Party are asking the court to nullify the presidential election in the interest of justice and declare the purported return of Tinubu invalid. Going by the arguments, you can see the strategy deployed by the Labour Party legal team. These lawyers know their onions. And this shows that they did not tender the total computed figures that they scored in the election. This is intentional. Although when the star witness was questioned about it, he said that the prof mentioned it in his statement. They all intentionally avoided this because of one reason. You cannot on one hand be telling the court to nullify the election because it was conducted in gross violation of the Electoral Act, and on the other hand be telling the court to declare you winner. You can't seriously tell the court that you won an election that was seriously flawed. Yes, but they still pleaded it in their petition. But that will happen if the court determines that the gross violation didn't affect the results, which will ultimately lead to the recollation of the results. Yes, Labour Party avoided not getting trapped in claiming that they won a flawed election, but they still gave the court the evidence that proves they won. So it's left for the court to decide, but let's not go deep into the analysis. It's better done in another video. Before we see their response on the 25% requirement in Abuja, let's see how they countered INEC on their thinking that they are not bound by statements they made before the election. If you remember, INEC claims and continues to claim that since there's a court judgment that permits them to conduct an election how they want, that they can say election will be conducted in a particular manner before election, and during the election they conduct it in a different manner from what they said. That there shouldn't be a consequence. The Labour Party disagrees completely by asking the judges a question. Whether INEC, having publicly represented and assured that it was irrevocably committed to complying with the law by electronic transmission and upload of election results from polling units to the IREV portal, is INEC not stopped from reneging from this publicly given assurance? In order to prove that the law of estoppel is firmly entrenched, they cited a Supreme Court judgment in the matter between Access Bank and NSITF 2022. The Supreme Court held, quote, "Instructively, it is right that plethora of cases reiterated the fundamental principles regarding estoppel. It was aptly posited by this court in Jacobs Oyeruba versus Ebewole, 1998. Estoppel is now more than a rule of practice, and it can be rightly described as a substantive rule of law. A person ought not to be allowed to blow hot and cold, to affirm at one time and deny at another time. That is to say, to approbate and reprobate, unquote. So in driving home their argument, Labour Party is saying that INEC cannot, after telling the whole world, in Nigeria, in Chatham House, in London, that they will transmit and upload polling unit results from polling units on election day, only to turn around and do the exact opposite and think they are within their rights to do so. People like Festus Okoye, who re-emphasized before the election that INEC will not abandon the upload of election results. Look at what he said in his latest interview. The worst part was that INEC representative who came to court under subpoena to present the statement that Festus Okoye released before the election denied and told the court that the press release doesn't exist and that it's not in their records. Imagine an institution funded by taxpayers denying their own press statements. Anyway, Labour Party downloaded the press release from INEC's website, they provided the URL, and tendered it in court during the hearing, and it was admitted in evidence. Also, Labour Party cited the recent Supreme Court judgment on Oyetola versus Adeleke that reinforced the mandatory upload of results from polling units. There's a lot more they said, but let's leave that for another video. On the threats made by Tinubu's counsel in their final address that the petitioners are inviting anarchy by their ventilation of this issue of non-transmission of results electronically by INEC, the Labour Party described it as a cheap, misguided, and destructive blackmail clearly intended to target the country's judicialism and constitutionalism. It also aims at cannibalizing our democracy. When has it become offensive for petitioners to canvass a ground prescribed for the challenge of an election? Desperation taken too far can be extremely dangerous. Now, let's see how they tackled the 25% requirement in Abuja. Remember that Tinubu's counsel, after arguing against it, ended up agreeing that the "and" is conjunctive. And reading their submissions further, it seems that they agreed that 25% is mandatory, but it's 25% of 2/3 of the votes cast in Abuja. They said that total valid votes recorded in FCT is 460,071 votes, and 2/3 of this number is 306,714 votes. That 25% of this number is 76,678.5. And going by what INEC announced, Tinubu scored 90,902 votes. So they are trying to say that Tinubu made 25% requirement going by Awolowo versus Shagari election dispute. Are they confused? So after arguing that it wasn't required that Abuja should be treated as a state, now in this new reply they are saying that it's 25% of 2/3. Wow. Is that the way it is calculated in the states? It is based on total votes, not 2/3 of the total. Let's even assume they are right, but why will Abuja be calculated differently? Imagine what will be going on in the mind of the judges when they are reading this. Anyway, let's see what the Labour Party legal team said that forced them to quickly accept that 25% is mandatory. On their reliance on Section 299 of the Constitution, which says that Abuja should be taken as a state, the LP legal team cited a Supreme Court judgment delivered in 2022 in the matter between FRN versus Ngajiwa. The Supreme Court held that the interpretation of the provisions of the Constitution, where the words of the Constitution are clear and unambiguous, a literal interpretation will be applied. Where there is ambiguity in a literal interpretation, a holistic interpretation will be resorted to. All sections must be read together and purposefully, so that no section is rendered redundant and superfluous. If the words remain ambiguous, the intention of the makers of the Constitution must be discovered to determine the mischief sought to be cured. The court is entitled to consider how the law stood before the statute was passed, what the mischief was for which the old law did not provide, and the remedy which has been provided by the new law. They also cited other judicial precedents to support the correct interpretation of the Constitution. They cited other court judgments that delivered judgment based solely on the interpretation of Section 299, which affirmed that Abuja should be treated as a state. But they insisted that in the case of Abuja 25%, the court must interpret Section 299 together with Section 134, subsection 2. They also said that the presidential election dispute between Awolowo and Shagari that the defendant cited doesn't apply in this case because going by the 1999 Constitution, there's an additional requirement for FCT. That reading the entire section 299, what they mean by Abuja should be considered a state is for the purpose of enjoying the executive, legislative, and judicial powers vested in a state. That's why the president is the governor of the FCT, the National Assembly legislates the local laws of the FCT, and the FCT High Court has territorial jurisdiction in the FCT. To support this argument, they cited the judicial precedent Iwuchukwu versus Attorney General Anambra State 2015. So going by this, if section 299 is read separately, the LP legal team argues that it will render redundant the wordings of the drafters of the Constitution in section 134, subsection 2b. Yes, especially where it says "and the Federal Capital Territory." If Abuja is a state, why didn't they just say 37 states of the Federation? Also, it makes no sense that in section 3, subsection 1, where the 36 states are enumerated, Abuja is missing there. So they are telling the court that the literal interpretation of section 134, subsection 2b is that a candidate must secure 25% of votes cast in the 2/3 of the entire 36 states of Nigeria and 25% votes cast in FCT. That the word "and" has been defined by the Supreme Court to be conjunctive, which makes it mandatory. Also, "and" has been given judicial interpretations in many cases, for example, Abubakar versus Yaradua 2008. On the use of the word "each" in the states of the Federation, they contend that the specific mention of a class is to provide for the person specifically mentioned, to the exclusion of others not mentioned. To support this argument, they cited a judicial precedent in the matter between Grand Systems Petroleum Limited versus Access Bank PLC 2015. They also told the court that the fact that section 299 states that FCT is to be treated as a state is a general provision which has no bearing on section 134. That the 1979 Constitution was silent on 25% requirement in FCT, but in 1999 Constitution, the drafters deliberately amended the section to include 25% in FCT, partly because they intended that the popularity of the winning candidate must extend to the FCT, being the capital city and melting pot for all Nigerians, that it will truly reflect the will of all Nigerians. The respondents are wrong in the approach they have taken to the interpretation of the intention of the makers of the Constitution as it relates to section 134, subsection 3b. And this section must be interpreted with section 14 of the Constitution, which says that sovereignty belongs to the people of Nigeria, from whom government through this Constitution derives all its powers and authority. Also section 2, where it says Nigeria shall be a federation consisting of states and the Federal Capital Territory. Governorship elections were held on March 18th. None was held in Abuja. In conclusion, they urged the court to discountenance the respondents' defense as devoid of any scintilla of merit and hold that the petitioner's case is meritorious and grant them their reliefs. Now, let's see their address on Tinubu's forfeiture. On the claim by Tinubu's legal counsel that Tinubu's forfeiture judgment was not registered in Nigeria and therefore cannot apply in Nigeria, the LP legal team countered by saying that the judgment being documentary evidence is certified, sealed, notarized, and authenticated by the United States Court which issued it. They reinforced their argument by citing one judicial precedent delivered by the Supreme Court in 2004 in the matter between MV Delos versus Ocean Steamship Nigeria Limited. The court held, quote, "A party who intends to rely on the judgment of a foreign court must comply with either of two options, namely, A, by sealing the judgment with the seal of the foreign court, or B, by a copy certified by the legal keeper with a certificate or of a notary public or of a consul or diplomatic agent stating that the copy is duly certified by the officer." They asked the court to uphold that the judgment against Tinubu, which they tendered in evidence, met all the relevant conditions. They also debunked the claim by Tinubu's legal team that the judgment must be registered in Nigeria. If you remember, they quoted section 3 of the Reciprocal Enforcement of Foreign Judgment Ordinance. But Labour Party insists that they are not seeking to enforce any money judgment against Tinubu. They are not trying to recover any money payable under foreign judgment. So the act the respondent quoted does not apply in this case. On the citation of Article 54, subsection 1c of the United States Convention Against Corruption by the respondents, the said article talks about member states providing mutual legal assistance concerning property acquired or involved in the commission of an offense established in accordance with the convention. LP's legal team argues that Tinubu's judgment they tendered in evidence has nothing to do with mutual assistance. Therefore, the UN article the respondent cited is irrelevant to P2B's petition. They went further to argue that the main issue is whether a civil forfeiture under U.S. law as ordered by the U.S. court in Chicago can be equated to a fine as used in Section 137 subsection 1D of the 1999 Constitution. Of course, the answer is yes. In support of this claim, they cited a judicial precedent in the U.S., Austin versus United States, in 1993. In that unanimous judgment by the U.S. Supreme Court, the Honorable Justices held that forfeiture is a fine and is punishment regardless that it did follow from criminal conviction. The court also held that the U.S. Congress used the word forfeit for fine. They went on to cite many dictionary definitions of forfeit, which of course means fine. The LP legal team didn't stop here. They cited another U.S. Supreme Court judgment, Thames versus Indiana 2019. In that case, the state of Indiana filed a civil forfeiture proceeding against Thames. They claimed that his Land Rover SUV was used in transporting narcotics, which of course he challenged and appealed to the Supreme Court. The court held in a unanimous judgment that fines may be employed by the state in a measure out of accord with the penal goals of retribution and deterrence. That fines are a source of revenue, while other forms of punishment cost the state money. So the most important takeaway from all this is that all the judicial precedents cited by the LP legal team consistently define forfeiture as a fine or a punitive economic sanction against the persons whose property is affected. Thames, in one of the cases mentioned, challenged the forfeiture of his SUV, while Tinubu did not challenge the forfeiture of $460,000 narcotics proceeds. The question arises, why did he challenge it? It was because he suffered economic sanctions just like Tinubu. They also cited the Administration of Criminal Justice Act 2015, which interprets fine as, quote, includes any pecuniary forfeiture or pecuniary compensation payable under this act. Penalty includes any pecuniary fine, cost, forfeiture, or compensation recoverable under an order, unquote. Tinubu's counsel in their final address and even in court concentrated on the fact that he was never convicted, that he just forfeited money. But the LP legal team are saying that the section of the Constitution that their petition relies on is Section 137 subsection 1D, which disqualifies a candidate if he has been fined by a court. And in all the cases they cited, whether it's civil or criminal, it is still a fine. And if one is fined, it is related to dishonesty or fraud, which is covered in the same section. The LP legal team also cited judicial precedents in Nigeria where the Supreme Court defined forfeiture as a fine. In the first judgment, Attorney General Bende State versus Abofodo 1999, the Supreme Court held that forfeiture is an action of forfeiting something or being forfeited. It is a penalty, a forfeit. It is synonymous with a fine, penalty, damage, confiscation. Justice Igu of blessed memory was among the panel of justices that delivered the judgment. In the second judgment, of course, we made a video about this one, the celebrated case between Mohammed Abacha and the Federal Republic of Nigeria 2014. The current Chief Justice of Nigeria was among the panel of justices that delivered the judgment. They held that these definitions leave no doubt that forfeiture is a sanction, a fine by the court. It is penal and criminal in nature. So after all the citations both in the US and Nigeria, the two Supreme Courts defined forfeiture as a fine. Even in that of Abacha, the Supreme Court held that it is penal and criminal in nature. Based on this, the LP legal team are saying that the express meaning and intendment of Section 137, subsection 1D of the 1999 Constitution, a person, even though not convicted, have forfeited property on account of criminal conduct should not aspire to or be allowed to occupy the exalted office of President of Nigeria. In order to reinforce this claim, they said that the reason "or" is used twice is to separate persons convicted from persons who, even though not sentenced, are affected by an order of a fine imposed by a court. So this particular section is targeted at people that were fined by the court, as in this case Tinubu, and even if they are not convicted, they still fall foul of this section. In this same section, any court was used, so the United States District Court, Northern District of Illinois, that made the order of fine against Tinubu falls in the category of any court. Yes, some may argue that the drafters meant Nigerian court, but the Labour Party legal team argues that it is actually any court, that by using "or" to separate them makes it very obvious. Tinubu, having opened a bank account with the same address that the US Customs Service disclosed that it was a drop-off point for packages from Nigeria that contains narcotics. So despite not being convicted, his actions borders on money laundering and narcotics trafficking, which all falls under dishonesty and fraud. On the witness that they called, they said that the fact he accepted that it was not a money judgment means that registering the judgment is not required in Nigeria, in contrast to what they claimed. And it's fictional for the witness to claim to have a license to practice federal law across the United States. Also, his claim that the court relied on American law section 981, that it deals with civil forfeiture, is embarrassing and betrayed his claim of being knowledgeable in American law. So based on all this, they are asking the court to hold that Tinubu was not qualified to contest the presidential election and he should be disqualified. Their arguments on the double nomination of Shettima will be covered in another video because this one is already too long. Thanks for watching.